All right, Michael, thank you for joining me today. I really appreciate you taking the time to discuss this topic. For the record, I should say that anything we discuss is not official Law Society position on anything, and that we're just sharing our own personal views. Being both of us as benchers of the Law Society, I don't want anyone to misinterpret any of our discussion here as an official position. With that said, I'm sort of reminded of an article you wrote February 16th in the Lawyers Daily, sort of calling out the court and the court processes in Ontario. And I thought, it'd be great if we can touch on some of those issues that you've raised.
Well, certainly happy to discuss them with you. And I know, we obviously have a number of issues in the court system here in Ontario, just like other jurisdictions. And in some areas we're struggling a little more, and in other areas perhaps we're doing a little better.
Yeah, I mean, I initially, prior to us sort of discussing, I've read your articles, and I know this is not the first time you sort of called them out and spoke. Maybe tell me a little bit, if you can, tell us a little bit about your background. You came from, if I understand this correctly, from a U.S. jurisdiction, and then started practicing here in Ontario. So you probably saw the difference between the two court systems, and I'm wondering how much that played into some of your opinions and some of your articles.
Yeah, so excellent, excellent point you noted there. I went to school in Pittsburgh, and I saw, or law school anyway, and I saw a little bit of their court system while I was there. And just how the clerk of courts worked, for instance. And then I went down, got my license in Florida. I practiced down there for around 5 years. Like in Ontario, I practiced civil law in Florida, so I got to see one way, how a system worked, which across most of the U.S. the legal system is quite similar. They have a federal court system that has jurisdiction over certain types of cases, and most state court systems, to a large extent, will adopt the rules and procedures with some procedural, some substantive changes. But you end up getting a relatively similar system from one jurisdiction to the next, perhaps with the exception of Louisiana, which has civil law.
Interesting. Now, I don't know. I don't know if they're that flush with judges, or how, what the numbers are like in terms of total population, total number of lawyers, total number of cases. But from just a purely, perspective of how many cases they hear or the cost per case. I think you looked at that in one of your more recent articles. I think it was a SLAW article last year, and you compared New York, you looked at Florida and Ontario. And if I remember correctly, Florida did the best. They were in the roughly $92, cost. Maybe you want to explain that a little, because I don't want to misstate it.
Yeah, so basically, I just looked at the budget for the court system across several different jurisdictions, Ontario, New York State, Florida, and California, and basically just did the straight division by the number of residents of each jurisdiction. And New York State, for instance, was funding its court system in the approximate amount of $118 per resident of New York. Ontario, I think, was slightly lower at about 116, and then Florida was in the bargain basement at $44, $45 per resident. And they're doing all of the same things in all of those court systems as we're doing here in Ontario. Whether it's criminal trials or civil issues, family issues, or estates.
Interesting. So what are some of the issues? And I want to get back to that Florida example a little later, maybe, but what are some of the issues you're seeing in the court system now? What are some of the effects it's having on I would say lawyers, and I would even say their clients? I mean, assuming that some of those effects are passed on to the clients, ultimately the matters are all client matters, right? They're not, lawyer matters.
Yeah, so they're obviously, I guess the most pronounced effect in Ontario is just really, really long delays across the board, regardless of the type of case. So every year we're failing to get around to prosecuting several hundred accused criminals who are now being released because of the Jordan decision, which the Supreme Court has essentially termed our culture of complacency. And likewise, in the family law sphere, we're up to somewhere in the ballpark of 60%, self-represented parties. And likewise in the civil sphere, I've started to obtain some of the performance data that shows that even before COVID, cases that were going for jury trial in Toronto were on average about 5 years and 9 months old.
Wow. So let me understand that for a second. So when you say before COVID, we're talking about 10 years ago. And 5, 6 years before they get to trial. Is that what you just said?
So I obtained the data from 2019, which showed the number, and I've posted it on the resources section of my website. But basically, it showed that of the, number one, there weren't a lot of civil cases that went to trial in Toronto in 2019. Less than, I think there were exactly 234. So a relatively small number in a metro area. And, the average age of the cases at jury trial was 5 years, 9 months. And, roughly 1/3 of them were more than 7 years and 3 months old by the time they reached trial.
Wow. So I started looking, and maybe before we go continue, if you wouldn't mind letting everyone know where they can find you, your website, your Twitter, your LinkedIn handle. I know I forgot to sort of remind that, but that would be a good thing to share now, and maybe even at the end of our talk.
Oh, sure. So my website is Michael's Firm, and then .ca. One of the tabs in the navigation is simply resources. So when I do a Freedom of Information Act request, for instance, and put up the Civil Procedures Manual for the Ontario court system, or the notice from the Attorney General when they threatened to sue me for posting it, that's where people can find that sort of information.
What kind of reactions do you get when you share this stuff on social media? You just sort of said one, but what about from the lawyers? They say, "Oh my God, Michael, you're crazy," or they say, "Oh my God, you're right," or like what type of is it mixed, or is it all one-sided?
I think certainly a lot of lawyers that I deal with, they share the general frustration that our system has failed to keep pace with society. And, certainly before COVID, it was well behind the times. And even now it's struggling to catch up, but there's a lot of one step forward, 2 steps back.
Yeah, I can imagine. I litigated for 6 years, but haven't for many. And I know back then it was probably similar. I was sent when I articled, I was sent on a matter that to speak to a matter that was 11 years old, and I just got blasted by the judge. It wasn't my matter, obviously, but I was seeking an adjournment, and still 11 years old. It was it was quite the thing. And I know they came in with some processes to kind of move that forward, a civil trial list, I think it was, or some kind of trial list, but those are processes. So let's talk for a second. Where do you see most of the delays? Is it in the appearances, the request for appearances, or is it in the filing process, or what is it? Like where in your experience are you getting it?
So in the, on the civil side, we really have a few processes that aren't overly well thought out if the goal is to actually move cases through the system. Conversely, if the goal is to pad the bottom line of insurance companies, then our processes are masterful. And those processes are basically, they start with discovery. The Americans have adopted workable discovery rules, which basically say, if you're asking someone questions at discovery or a deposition, they should almost always answer the questions. And, if there's a problem with them, they'll take it up at trial as to admissibility, for instance. And, Ontario we like to pretend there's a judge in every room. So lawyers get into arguments and disputes, questions get refused. There's a lot of obstruction, and that leads to a cottage industry of refusals and undertakings motions. And that uses up a lot of judge time. So that's one example. A related example is in the States. If you want documents from the other side, you simply send them a request to produce, saying like, hey, to a cigarette company, you've said in your advertising that cigarettes are, part of a healthy lifestyle. Show me your underlying research that, from doctors and health studies you rely upon, for this conclusion. And likewise, show me anything that you have indicating that not to be the case. And in Ontario, for whatever reason, we've effectively delegated parties counsel as being responsible for determining what is relevant to opposing counsel, which again strikes me as a pretty dumb way of dealing with production.
Yeah. So the system itself, in terms of it allows too much leeway for lawyers that want to manage the process, cause delays, obfuscate, or create issues, and or increase costs, and sometimes for some form of further delays, because clients are either bearing the cost or don't want to deal with the matter right away, or need to save money to manage it sort of down the road.
Yeah, and I guess the one other, the one other, speaking of delays, which our system pretty much incentivizes, is there's a rule 48.04 that essentially delays the time when actions can get put in the queue for trial and pre-trial. And generally speaking, certainly from my experience, the sooner cases can get to trial, the more likely they are to resolve, and the sooner that is to happen, because at the start of a case, everyone is going to get 100 cents on the dollar, or they're going to be completely vindicated and have to pay nothing. But if you've got trials starting next Monday, things usually aren't looking quite as rosy by that point, and the sooner that happens, the sooner you actually get some things resolved.
Yeah, I had an old lawyer buddy who at one point in his career would really set matters down for trial right away. He wouldn't deal with refusals, motions. He wouldn't deal with any of that stuff. He straight away set it down for trial as soon as he could. And I asked him, I said, aren't you worried? Like, you need this information. The refusals aren't done. He said, no, the minute it gets to trial, everyone's the minute it gets before a judge, everyone is really having a good hard look at it, and 9 times out of 10 it's settled. And I thought that was interesting. Risky, I thought also, but I mean, he knew what he was doing. He was seasoned, but definitely interesting. The fear of trial tends to motivate very well.
Yeah, and certainly I would do the same thing when I was practicing in the US, because under their rules you could notice something for trial pretty much right after the defense was filed. And likewise, your discoveries would continue. Typically there'd be a timeline that would be set by the court. Here's your trial date, here's when your expert reports are due a few months before that, and here's when your discovery completion date is. And essentially it forced the parties to move the cases. When parties didn't move the cases, they got dismissed. And so we didn't end up with a lot of 11 or 15 or 20-year-old cases in the system, and people could get trial within a reasonable amount of time.
Would you say it was a more hard-nosed approach with lawyers and counsel, or was it just it was just the way the system was, and everyone was trained in that from the beginning, and that was it? What was your experience?
Well, I think it was just, obviously they had different values, in that it was important to them in the States that people could get a decision on their legal matter before they died. And, in Ontario, that's not as important. Likewise, it's not as important that we actually try accused criminals. We want to, give everyone the 4 or 5-star legal experience, whether or not they can afford it, and whether or not their case demands it. And as a result, we basically just can't do it. We can't accomplish it. And we end up with accused criminals walking free, and a lot of a lot of problems in family law, and a lot of problems in the civil system with delay.
So you're saying that there's too much in terms of too much focus on procedure and potentially procedural fairness. I don't think I'm hearing you say that, but I think we're just letting too many people get away with gaming the system is maybe more of what I'm hearing you say. Is that fair?
Well, I don't think it's necessarily gaming the system. I just don't think we've really set our system up to deliver results. And one of the ways that I think that's most apparent is, if we do have this great system that people like to, essentially assert is the case, much as I can say I'm the world's tallest person, if you stand me beside some basketball players, that's going to fall pretty flat pretty quickly. But if we do have the greatest system, that's fine. Let's get some statistics, and let's look at some different cases. How many people are walking free, for instance, in the criminal sector? How long it's taking to resolve cases, in family and civil. And then we can put this beside, very similar jurisdictions like Alberta or Michigan, New York State, Florida, Quebec, and we're either going to be the greatest, or we're not going to be the greatest, or we're going to be somewhere in between. But the stats that I've come across certainly indicate that we're going to be near the bottom or closer to the bottom of those lists, if not at the bottom, as opposed to the top, which is really the opposite of being great.
Yeah, for me, it was fascinating. I did some research ahead of time trying to, prepare. And I saw there was something like, I think in one of your articles, you listed about 1.6 billion as the cost of the court system in Ontario. That to me was kind of interesting. And then I thought, well, is this a judge problem? Is this a system problem? Or is it, lawyers have been trained to sort of maneuver and think about litigation in a certain way from their principals or mentors, and they were trained from their principals and their mentors. So is it something that came from there? And I'm not sure I have the answer, but I was shocked to see that we have about 735,000 active matters in Ontario in any given year. Family was something like 75,000, criminal was 240,000, and civil was 420,000 active. I think newly initiated civil matters are in the range of 200,000 per year. So for me, I thought, wow, those are a lot of numbers, pretty high numbers. Granted, we're 14 million people in Ontario, but we only have 52 court locations. We only have 583 judges that sit in courts, and not that doesn't include justices of the peace. So when I just do the numbers, 735 active matters divided by 583 judges, that's 1,260 matters per judge. If they were going to resolve those and they had, let's say, 3 weeks off per year and 3 weeks vacation, because I kind of accounted for Christmas and March break, I think my numbers were like, over 46 weeks, they would have to resolve 28 matters a week. I mean, that's never going to happen from what I've seen from just my own personal experience in the past. So I don't know if it's a judge problem, a system problem, or a lawyer problem. But I think from your perspective, from what I'm hearing from you, it's definitely the system can fix the judge and it's probably the first place we should look, if that's what I'm hearing.
Well, I think certainly for the bar and the bench, the easiest place to make changes is simply to the rules. And my recollection from when I practiced in Florida is a lot of our local state court judges, they would also have thousands of cases. Basically because cases there were assigned to one judge. So that at least if if a case went before a judge one time and then it came back another time, typically you didn't have to educate the judge from scratch. They had some familiarity with it.
Yeah.
But when you set the system up to minimize judicial involvement, especially with a lot of the things that really don't matter all that much, like scheduling, for instance, that if you go to your dentist's office, you don't talk to your dentist and say, I'd like to come in for a root canal. What day can you do? Can you do it? You talk to an assistant or a secretary.
Yeah.
And we, of course, burn judge time on that. Likewise, we burn a lot of judge time with our discovery rules and, having judges explore the academic question of, is this document or is this question relevant to a part of the pleadings when read liberally, or, is it properly refused? Whereas, certainly in my view, the smarter answer is the American one, which is, answer the damn question. And, if there's a problem with admissibility, we'll deal with it at trial. But of course, 2 or 3% of cases make it to trial, and, everything else makes it to that pretrial or the settlement conference, gets resolved. And so you never have to waste that judicial time on those academic questions. You can actually spend it getting to the bottom of things.
Yeah. So you've been beating this drum now. Have you've gotten any anywhere with from the Ministry of the Attorney General's office, or are there any joint committees that you've been working with or trying to get on that you want to see, look at? Because I know there's maybe a civil rules committee. There may be, different committees that are involved at looking at this. Do you know if there's any initiative at this point trying to look at this? Because I think ultimately it's an access to justice issue, 5-6 years for a trial, a civil trial. I don't know what it is in criminal. Family seems to be a mess in general. I spoke to someone yesterday, it's anecdotal, but they mentioned that if they filed a new matter in family, it would be 6 to 8 months before the first appearance, if it's a case conference or whatever the appearance is. Have you seen any take up by anyone on this? Is there any movement on looking at this?
So I can tell you or share a funny story with the Ministry of the Attorney General. So the court system, they have their own internal civil procedures policy manual as to how their staff is to apply the rules. So I did obtain that, and I posted it on my website. And very shortly thereafter, the Ministry of the Attorney General sent me a cease and desist letter threatening litigation if I didn't take it down. So I remain somewhat at a loss as to why a document like that was released under the Freedom of Information Act that pertains to how a public body operates, cannot be disclosed to the public or the users, especially given that, our court system, they're arbitrarily rejecting 1/3 of all documents submitted to them. So, I thought that was pretty interesting.
What was the reasoning? Did they say cease and desist because in the public interest, you're doing something that is wrong? What was that? What was there a reason given, or was it just simply cease and desist?
Well, I think they claimed copyright, but I did post that letter as well on my resources page, and as soon as I got it, I posted it on Twitter. I thought the bar would be interested to know that how our court system operates is essentially a state secret, and candidly, given their level of performance, if I was in charge, I would probably also want it to be a state secret, because I'd be kind of embarrassed at how they're doing, especially compared to other jurisdictions.
Now, in fairness, Superior Court, judges are appointed by the federal government, right? But is it all run by the Ministry of Attorney General here in Ontario, or is it's all run federally, and that kind of mixes with the Ontario, the OCJ? Do you know? I don't know. I can't say that I know for sure.
Well, you're correct. And, in my experience, obviously, is just in the civil system. So we basically have at least two cooks in the kitchen. One, of course, being the judiciary that's appointed federally. And then we have the Ontario Ministry of the Attorney General that runs Ontario's court services, which are their own unique creature, especially as you get closer to the GTA or larger centers.
So you are causing a bit of a ruckus, kind of pushing for information, posting information. And you're saying about 1/3 of every case that gets filed gets rejected. Now, what's that all about, if you don't mind me asking?
Yeah, so typically court services functions as, to a large extent, the library. In civil cases, the parties have documents, they typically file them with the court, they in some cases pay a filing fee, and the other thing they depend on court services for is if they need a hearing, they call them to schedule a time before a judge. That realistically is it. And in Ontario, court services, they have their own method of operating. So, a few of the funnier stories I have is before COVID, I sent, I mailed something into the Hamilton courthouse by registered mail. And a month later, it came back to me because, despite the fact the courthouse takes up a city block, the employee that was responsible for picking up the mail was on vacation. And so no one picked up, the mail. And, likewise, mail comes back. All sorts of documents are rejected for all sorts of reasons. Sometimes like, hey, you didn't comply with this minor rule. We don't like your font. You didn't serve this party that was dismissed from the action. Well, yes, you're correct. I did not serve a party dismissed from the action because they're no longer in the action. And so it just adds a lot of time and a lot of headache at lawyers' offices.
Yeah.
And it adds basically, and it of course also adds cost, and it doesn't actually add really any benefit. Certainly not one that's outweighed by the cost.
So it's more of a frustration that a lot of lawyers have to deal with, and it probably adds more cost to the to the client in the end of the day because of the inefficiencies in the system over things where you've got to constantly go to a judge that could possibly go to a registrar or be managed differently, is what I'm hearing.
Well, in a lot of cases, you're literally just trying to have a document added to the court file, or essentially the legal library. And it's getting pushed back to you sometimes repeatedly, and it certainly makes the system less efficient. If the lawyer or the law office doesn't charge for that time, it results in lower tax revenues for the government because obviously they're not earning something. If they do charge their clients, the clients are basically paying for something that has or should have no value, because all you're literally trying to do is say, here, Joseph, have my document for your records, and you're sending it back and saying, Mike, I don't like the font you used, in the top right corner here, and well, I don't really care. Just put it in your file and leave me alone.
I filed a few Court of Appeal and Federal Court of Appeal matters, and the stress associated with understanding the color of the back page, the size of the font, and all that was something I still remember. But to have things rejected and they go, whoa. I filed the state applications, and I remember it depended on who the person sitting was. There was a style that one person liked versus minimum requirements that another person liked. So what one person would pass, another would fail, or the file will come back 3-4 times as a result of something missing, and then a second subsequent review by someone new that came back, and oh my goodness, the frustration. And try to explain it to a client who's already emotionally charged and dealing with a bunch of other issues and excess costs as a result. So I definitely can feel the pain. So what do we do? What any suggestions? What do you think the answer is? And is it throwing more money the answer to it? Like I think of the Florida jurisdiction, and I know you and I talked a little bit about this offline, where Florida doesn't charge income taxes, if I understand that correctly. So all of the revenue that goes to running the courts would probably come from property taxes and some other sources of revenue, I imagine. Is throwing money at it the solution here in Ontario?
So ultimately, I think we have to decide what we want. I think that's really, what is the goal is, really a good first place to start. And, if we want to have a justice system primarily for the benefit of the insurance companies and the big businesses and the rich, then I think we leave it alone because I think we're really delivering well for them, for that particular constituency. They've got the Rolls Royce of legal systems. For corporations, it might not matter if a claim takes 7 years or 12 years to resolve. They have the ability to, pay the money to wait. They're not going to die in the meantime. And, so if that's the goal, leave it alone. Conversely, if we want to try to have a legal system as good as competing jurisdictions, I think we need to say, okay, across different types of cases, kind of like the Supreme Court forced us to do in Jordan, if you want to try someone for a crime, you're going to have to get them to trial within 30 months, which is still about, 2.5 to 5 times longer than in the US. But you kind of start with the goal, and likewise you do the same thing in family. If you have a family breakup, how long from case filing to case resolution or to a final order, and likewise in a civil case, how long from filing to a decision. And then once you've set your goals, okay, what do you have to do and what rules do you have to change to see those goals accomplished?
Yeah, certainly there's got to be someone who understands where the biggest delays are caused as a result of certain rules, and maybe it's the rules is the first place to look and start. I mean, your article in the SLAW, I don't remember what that stands for right now, but talked about how was it Derek Chauvin and George Floyd, both matters were tried, not George Floyd, but the I guess it was Derek Chauvin, convicted for murder, was tried within a year, less than a year. And we've set this new standard of, what is it, 2.5 years now. So it's not looking like it's getting any better. And I think, having these kinds of conversations and having someone that will call them out and sort of say, hey, we need to be looking at this, because you've probably, had your fair share of frustration seeing the two systems. I think it's a great thing. I don't know where we go from here, but I'm hoping that you'll be on some form of a rules committee, or, you'll have a seat at the table eventually to, with the powers that be that are looking at this.
Well, I certainly appreciate that. And I think, part of my frustration is I did go to school in the States, obviously with a lot of my fellow students who became lawyers. I didn't like thinking at the time that I was only 40% as competent or, as smart as all of the other people in my class.
Mhm.
And, I likewise don't like thinking in Ontario that, we're only as good, 40% as good as, lawyers in all of these other jurisdictions, or that, our judges are only 40% as good as, judges across the border in Michigan or, New York State. And we have some phenomenal judges, some phenomenally smart judges, much smarter than I am, much better legal scholars. But certainly I'm concerned that when we look at the outputs and the metrics in terms of what we're actually producing and, what's going through the system, we're just not hitting the volumes, and we're not hitting the reasonable timeframes that our competing jurisdictions are accomplishing.
Well, listen, I really appreciate you kind of highlighting these things, and hope you keep going with the message, and it develops into some form of change, at least one small step forward. And again, for our listeners, if you can, where would you like them to connect with you? Is it Twitter? Is it LinkedIn? Is it on your website? Maybe give us that again.
Yeah, so I'm happy to, if anyone wants to shoot me an email, it's michael@michaelsfirm.ca. Or just Google Michael Lesage, and you'll see I own all of those search results. Likewise, I'm on Twitter at Michael's Firm. You can also look me up on LinkedIn, but I'm certainly happy to hear from anyone. And I do try to respond to everyone that reaches out to me. So happy to hear from anyone.
Great, and I'll post those in the notes section below once we post this. And thanks again. Anything else you want to say? Anything else you want to throw out as we end this, or are you good?
I think I think that you've covered, a lot of the important points, and of course, there's always more to talk about. Maybe you'll have to have me back, and we'll talk about this another day as well.
Would love to. Thanks again, and appreciate your time.
Okay, thank you as well, Joseph.